Good afternoon. How is everyone doing today? We are excited to have the second installment of our Digital Diversity Days, as we so affectionately call it D3. We have a packed house today in the Zoom room, so we're excited about that. Greetings from Johns Hopkins University, the Office of Multicultural Affairs. I'm Joseph Colon. I am one of your co-hosts today, amongst some dignitaries who are here with us and professional staff. I'm the director for the Office of Multicultural Affairs, as I said, and I hope everyone is faring well under the conditions. Obviously, COVID has prompted us to work more from home, use Teams and all types of digital platforms. So just to give you a brief idea of why we're doing this, we actually developed this program before COVID-19. And so we thought it was appropriate for us to continue the program as we were intended and really look at the concepts and also the theory and models around critical race theory. And so we want to acknowledge folks who are here, who have registered. I'd like to acknowledge the JHU community, particularly the faculty, staff, and especially our students who continue to do the great work, who are in the middle of academics and are joining us today. And so good luck on your finals. We are here if you need us. And so I also wanted to reach out to other professionals who are connected, our alumni who are also here. And so thank you for joining us as a full community today. So again, the purpose for us today is just really to talk about critical race theory, go in depth with the content, and more specifically today, we'll be looking at AsianCrit. And so we have our esteemed professor on deck who's going to be providing us with really amazing content and introductions to CRT, but most importantly, I'm going to be specifically talking about the AsianCrit. Joining us today is our Assistant Director for Programming, Kwame Phillips, and he is going to launch this and get us started.
Awesome. Well, hello, everyone out in the virtual world. I am Kwame Phillips, Assistant Director for Programming, as Mr. Joseph Colon has stated. We're delighted to have you all a part of this inaugural series that we're calling the Digital Diversity Day. We have Professor Robert S. Chang, and he wants us to call him Bob, but for the formality of the introduction, I will use Professor Chang. So here's a quick bio. He has a very extensive bio, and his work is very extensive in the critical race theory. Professor S. Chang is a professor of law and executive director of the Fred T. Karamazov Center for Law and Equality. He has previously served as the Associate Dean for Research and Faculty Development. He joined the School of Law from Loyola Law School in Los Angeles, where he was a professor of law and the J. Rex Dibble Fellow. A graduate of Princeton and Duke Universities, he's written in the area of race and interethnic relations. He's the author of Disoriented Asian Americans Law, Asian Americans Law and Nation State. He's also the co-editor of the Minority Relations, Intergroup Conflict and Cooperation. And he's written over 50 article essays and chapters published and leading law reviews and books on critical race theory, Latin crit, and Asian American legal studies. He's currently working on 2 books, one on the political and legal struggle over Mexican American studies in Arizona, and the other is the United States Supreme Court and white social dominance. He has received numerous recognition for his scholarship and service. He was the 2009 co-recipient of the Claude Ferguson Award given by the Minority Group section of Association of American Law Schools, which is granted to an outstanding law teacher who's in the course of his or her career has achieved excellence in the area of public service, teaching, and scholarship. He became an elected member of the American Law Institute in 2012. He is the co-recipient of the 2014 Charles A. Goldman Distinguished Award from the Legal Foundation of Washington for his leadership role in the state task force on race and criminal justice system. For several years, he has been serving as co-counsel in 2 cases in Alaska, challenging the involuntary psychiatric hospitalization and for psychotropic medication of Native foster children. He's also been working with his students from his civil rights clinic, who's been helping and assisting with those cases. We're so delighted that each one of you all have joined us virtually to really engage with Professor Chang as he goes in depth about the Asian critical race theory. There will be an opportunity for you to engage 3 ways: through Q&A, anonymously, as well as you'll be able to engage through chat. And if you would like to ask the question via video, there will be opportunity throughout the presentation. All right, now we pass it on to Professor Chang.
All right, so good afternoon. Thank you, Kwame, for the very generous introduction. And thank you, Joseph, also for the invitation to come speak with you. This is a strange world we're in, where it's like I would love to be, you know, in a room with all of you to engage with you, but I do appreciate being able to appear virtually. And so I also want to thank Johns Hopkins University for their support of this program. And, you know, so this opportunity then to talk about critical race theory and Asian Americans. And so, you know, that's the title in some ways of my presentation. What does critical race theory have to do with Asian Pacific Americans? And I'll give you the answer, quick answer right now. And I'm going to say it has a lot to do with Asian Pacific Americans. And so, let's see. I'm just trying to make sure. Okay, so I just want to make sure that the screen is progressing. I believe that it is. And so here's the outline of my talk. I'm going to talk about the Korematsu Center and myself just briefly, although after Kwame's introduction, I don't know what else there is to say. Then I'm going to move on to the current moment, the Chinese virus, Kung Flu. Then I'm going to locate this moment in history. And I've built in a couple of formal breakpoints, but again, as Kwame indicated, if you have questions, you know, as we go along, I think it's great. Ask them, and I will try to address them as I see them. So a little challenging in terms of monitoring the Q&A box and the chat box, but I'll try to do that. Then after that, I'm going to switch to a discussion of what some scholars have called differential racialization. And then after that, I'm going to return to the current moment. And so the Fred T. Korematsu Center for Law and Equality, we started it 11 years ago at Seattle University School of Law. Fred Korematsu is the Japanese American who during World War II said no when the US government said that he needed to report to an assembly center, that he needed to leave the West Coast. And the assembly center was the station that would then lead to the incarceration camps in the interior of this country. And he had the temerity to take his case all the way to the US Supreme Court. Those of you might know that he lost, that the US Supreme Court decided that it was okay what they did to Fred and to Japanese Americans. And so what we do is we're working to advance his legacy. And so he's somebody who said no to injustice. And it wasn't just that he took his case to the Supreme Court and lost. Approximately 40 years later, when new information was discovered, he actually challenged again his wartime conviction, and it was overturned. And he's taken this struggle, this vision of fighting for those whose rights are trampled on, and he extended it. He was very active, for example, following 9/11, trying to, speaking around the country, talking about the dangers of scapegoating of Muslim Americans. And so in the center, we really have 3 sort of things that we do. We think a lot. And that's because we're in an academic institution. And then from our thinking, we talk, and the talking takes the form of writing and teaching. But then the other thing that really drew me in some ways to start this center was to try to take these ideas from critical race theory and to put them into action in civil rights litigation. And so here's a sampling of some of the issues that we do in the center. We do a lot of work on race and the criminal justice system. We've done work on the death penalty in Washington state and also in Louisiana. Jury selection in a number of states, and also juvenile justice, ethics studies in the classroom. And that's something that I'm going to return to at the very end. But for several years, I was co-counsel to high school students in Tucson, Arizona, who challenged the Arizona law that was used to terminate their school district's very successful Mexican-American Studies program. Finally, after 6 years, we got to go to trial. I got to make my first objection in a courtroom. In some ways, I've had a reverse career. I went straight into law teaching, and now I'm just privileged to be able to do things now in the courtroom. But it's sort of like on TV. The other attorney says something, and you just pop out of your chair. I said, I object, and then the judge said, on what grounds? And I sort of scratched my head. It was like, oh, I need a reason. And fortunately, the reason that I came up was sustained, but fascinating experience. But their rights were ultimately vindicated. The judge found that the law was enacted and enforced in violation of the First and 14th Amendments. Kwame talked a little bit about my work in Alaska. We've worked on racially disparaging trademarks, the Muslim travel ban, the transgender military ban, rescission of DACA, recently climate change and the impact on minority communities, and just in the last couple of weeks, decarceration to address COVID-19 in Washington prisons. So I came to this, so I want to say a little bit about my path to critical race theory and civil rights advocacy, because I think it's important for you to know where I come from. One of the things I think in critical race theory that's very important is to understand people's subject position. And so I'm an Asian American who grew up in Ohio. The town I grew up in was about 3,500 people, maybe 99.5% white. Helps to explain in some ways why my Korean is so poor, even though it was my first language. One of the most formative experiences that I had growing up occurred when I was in 6th grade, and I endured a month-long festival of name calling, the usual names that Asian Americans are called. But then one day, one of my classmates called me the N-word, and in some ways, that's the thing that really devastated me. The rational part of me wanted to say, but I'm not that. But in some ways, I was that to them. I was the other in their midst. And I would never say that or claim to know what it's like to be an African American in US society, but I do know what it is like to be an other, and that's what motivates me and a lot of my work. Now, the thing is, many of us have experiences like that, but a lot of times we don't know what to do with them. We bottle it up, and probably that's something that I did for much of my life. And then when I got to law school, I took feminist legal theory. And feminist legal theory is something that started to give me a language to understand the things that I had experienced, but also to develop the tools to think about, okay, what might I do to change these things? And then it was through feminist legal theory that I got introduced to critical race theory. And that was very powerful in helping me to understand my prior experiences, but then to give me the language and the tools to try to make a difference. And that's what I've tried to do in terms of my scholarship, and then also in terms of the work that I do. Now, I want to switch from the introductory materials to talk about a moment, this moment. This photograph may be familiar to many of you. Gotta love the ubiquity of smartphones and cameras, and this is President Trump, a speech that he gave, and you see that his remarks said the coronavirus. He crossed it off and he put the Chinese virus. It was reported also that somebody or people in his administration were calling this the Kung flu. And, you know, I love wordplay. And so there's a part of me that's like, wow, that's kind of cool. Kung flu, clever. But there's a real danger when words like this are used. And so many of you may be familiar with the phrase dog whistle politics. There's this really wonderful book by Professor Ian Haney-Lopez, who's a law professor at Berkeley. And I'm trying to remember, I think dog whistle politics is in the title. You know, the idea of the dog whistle is that you're able to signal to certain people who are able to hear it, to, in some ways, to express something in a disguised or somewhat disguised format that activates the racism, the racist tendencies in audiences, to signal in some ways that you're connected, that you're with them. In my work, the idea behind dog whistle politics, there's a longer generation to it, and it's the use of racially coded language. Now, one of the things that I have found so frustrating about law and civil rights and anti-discrimination law is that in order to win, in most circumstances, you need to prove intentional discrimination. And so then the question is, well, how do you prove intentional discrimination? How do you show that the person who said something or who acted was motivated by racial animus? Well, in the old days, it was easy because people expressed openly their views regarding racial superiority, race inferiority, but then things started to change. And so there's this amazing interview that's reported in The Nation, and it's an interview of Lee Atwater, who was the chair of the Republican National Committee. And he talked about how, sure, in the old days, it was easy. You just said the N-word this, the N-word that, and you were able to galvanize your political supporters. But then he said you couldn't do that anymore. And so they shifted to words like school choice, neighborhood schools, words that seem neutral, but that are actually intended to communicate something very different. And so it's this idea of racially coded language. And so I think it's important when we think about, well, what's wrong with President Trump saying the Chinese virus? What's wrong with people in his administration saying Kung flu? And to understand this, I think you need to understand the substrate of anti-Asian animus that is intended to be activated by this dog whistle. Now, the thing about it is that there is such fertile ground for this. And so, you know, here are a couple examples from the sporting world. And so Nancy Kwan is an American ice skater. In 1998, when I think Tara Lipinski, another American skater, beat Michelle Kwan, MSNBC had a headline, "American beats Kwan," sort of eliding that Michelle Kwan is American. This got a lot of uproar, but then in 2002, when Sarah Hughes won, another very similar headline, "Hughes, as good as gold. American outshines Kwan." And so in some ways, the fertile ground in terms of the danger of words like Chinese virus is that it invokes and appeals to the notion of people of Asian American ancestry, people of Asian ancestry in the United States as being foreign, as being foreigners. And so there's this idea in some ways of being forever foreign. And so there's a shift from, you have China, and then you have the Chinese, and then you have the connection with Chinese American, and then because of what some scholars have written about, you have this idea of lumping, so that all Asian Americans are Chinese American. I mean, you know, it's, I'm sure many of you have heard stories like this or experienced things like this in your life. You know, one of my favorites is, you know, it's the "where are you from" question. And so, where are you from? It's like, this happened to me in a restaurant some years ago. And I said, I'm from Ohio. And they kept going on until finally they asked what my ethnicity was. I said I was Korean American. And then they proceeded to tell me about their trip to China. It's like this lumping that occurs. But it occurs because of the slippage between the nation China to the Chinese and then Chinese Americans. And in the same way, this came up in the context of President Trump and his criticism of Speaker Nancy Pelosi, where she was talking about Chinatown in San Francisco. And for some reason, President Trump seemed to conflate Chinatown with China. But again, this is what happens. Now, in terms of thinking about the specifics, locating Asian Americans in America's racial topography. So what I want to explore in this section is to talk about the different ways that this country has tried to categorize, racialize Asian Americans. And so one of the first efforts took place in a case called People versus Hall, 1854, the California Supreme Court. George Hall was a white man who was convicted of killing Ling Sing, a Chinese immigrant. And part of the testimony that convicted him was from Chinese witnesses. Now, the statute in place in California at that time said that no white person can be convicted based on the testimony of a Black person or of an Indian. And so the California Supreme Court had to wrestle with this. Well, what are the Chinese? And so in this remarkable opinion, the California Supreme Court said, well, we're going to treat Black as non-white. And so the Chinese are Black for purposes of this statute. And so we're going to exclude this testimony, and George Hall's conviction will be overturned. But then they said, oh, well, in case we're wrong about that, because of this notion that Indians, Native Americans in the US, had come across the land bridge from China, Indian in the California statute includes the Chinese. And so there was this need to protect whites from the testimony of the Chinese, and they got clever in terms of working with the statute that was in place. Now, very quickly after that, the California legislature modified the statute to name Mongolians by name. But so this is an effort to maintain, in some ways, white supremacy in the United States, and this is one of the early efforts. Now, the other way to maintain white supremacy in the United States is to keep Chinese people out. And eventually you got what was the first in a series, the 1882 Chinese Exclusion Act was enacted. And so then you had can Congress exclude the Chinese by name? You had a case in some ways testing that in 1889. This is the case of Che Jianping versus the United States. Now, as part of Chinese exclusion, the later amendment said for those who were already in the United States, if they want to go visit China, they need to have a certificate saying that they were legally in the United States. So Che Jianping got the needed certificate. He went to visit China, and then unfortunately, on his way back, Congress changed the rules and said, these certificates that we said you needed, they're just void. And so he arrived in San Francisco on the steamship Belgic after a month on the seas, and the commissioner there, support commissioner, said, you can't come in. And the US Supreme Court decided this case, and this case is remarkably important in understanding the discrimination that was made possible against people of Asian ancestry, because this case is the basis for what's called the plenary power doctrine. Now, most of us learn in civics that the US Supreme Court is to act as a check on the executive and the legislature. So that if the executive steps out of bounds or if the legislature steps out of bounds, the US Supreme Court is able to say, no, that what you did is wrong. But in Che-Jianping, the court, in a remarkable decision where, and on the right-hand side of the slide, you see the language that's used, this idea of Oriental invasion. The West would be overrun by the Chinese. It matters not in what form the aggression and encroachment come, whether from a foreign nation acting in its national character or from vast hordes of its people crowding in upon us. Now, let's think about that last phrasing, right? So the threat is from is there, whether it's from the nation or whether it's from its peoples. So then you have the conflation between the nation of China and its peoples, the Chinese, and the threat is the same. It doesn't matter. And what the court did in this case, this idea of the plenary power doctrine, the court said, well, with regard to matters of immigration, who gets to come in, what the rules are, we're going to say that whatever Congress does is fine. We won't examine it to determine if it is constitutional. And so this is remarkable because what this does is it places the actions of Congress and the executive with regard to the border outside of the purview of the Supreme Court. It places it outside of law. And you might hear in this how this is connected to Trump versus Hawaii, the travel ban case, and maybe we can ask, have some questions that come from that. Now, after that, they started not mentioning the groups by name, and you get the 1917 Geographic Barred Zone Act. And so I just love this map. And so instead of naming the countries by name and saying, Indians can't come, and on like that, they just said Asia, and then they talked about longitude and latitude. It's a remarkable provision, and this is the Asiatic Barred Zone when they wanted to stop immigration from South Asia. And so I've been going on for quite a bit. I think, intended to have my break for questions a little bit later, but I'm thinking maybe that this might be a good time to see if anybody has any questions. So let me just pause here. And if not, I'll just keep going because, it's like.
I think we have a question.
Okay.
And it's in the Q&A area.
Sure. So this person is wondering if there has been any AsianCrit literature about the implications of the aggregation of Asian subgroups, especially given that particular groups such as Southeast Asians face systemic socioeconomic barriers that are not as prevalent among other subgroups such as low income, lower educational attainment, and increased risk of deportation. In your view, is it problematic to study AsianCrit in a monolithic way? And so I'm going to begin by saying, yes, it is problematic to study AsianCrit in a monolithic way. And so, in other words, it becomes very important to understand when there is lumping going on, aggregation, and when disaggregation is necessary. And so one of the most important, one other sort of theme or trope, in addition to this idea of forever foreign, is the idea of Asian Americans monolithically being a model minority. And this construction of Asian Americans as being a model minority is something that erases the unevenness in terms of the different groups and the different histories of the different groups coming into this country. And it also erases the unevenness in terms of the disparities that exist within any group. So with regard to a particular subgroup, You have the privileged and the underprivileged. And so it becomes very important to understand when you aggregate and to be conscious and aware of that, but also when you disaggregate. Now, what happens sometimes is that activists sometimes in the political realm try very hard to talk about the commonalities between the different Asian subgroups, Asian American subgroups. And part of that, in some ways, is intended to understand that political power resides based on numbers. But again, there are dangers in then not understanding how there might be erasures that do exist. And so there's a lot more, I think, that can be said on that, but let me go on to the next questions. And so, so there's a question actually from somebody I know, a professor. It's in the Q&A, so I won't say the name, but could you address the Trump green card suspension order and the relationship of that to the Immigration Naturalization Act? Was this done as an executive order? Is there any authorization for such suspension? And so many of you may have seen this week, initially a policy created by tweet where President Trump says he's going to stop immigration. And then it becomes he's going to pause immigration. Then he's going to pause the issuance of green cards. Now, part of what the earlier history tells us in terms of US Supreme Court jurisprudence, and then also even leading into Hawaii versus Trump, the executive has tremendous power in the area of immigration. I mean, that's one of the legacies of the earlier anti-Asian exclusion laws and the Supreme Court jurisprudence doctrines that developed from it. It's interesting then thinking about, has he exceeded his authority in the way that he did this, including possibly the reasons that he has put forward for this. And I wish that I could give just an easy answer to this, but it's exploring this is going to take a longer, I think, than I'm able to in the time that I have. I think that what we're going to see is we're going to see legal challenges to this. And then what we're going to have to figure out is within the framework, what is going to happen in the federal courts. If I were to guess, my prediction is that this might follow a course similar to what happened with the Muslim travel ban, where initially it's stopped by the lower courts and even by the intermediate appellate courts. But the signaling in some ways is quite possibly that in Trump versus Hawaii, that at the end of the day, will the US Supreme Court say he can't do this? And I think that they will say he can do this. That's just what my prediction, my opinion of what they're going to say, which then highlights in some ways the need for, if you can't count on law because of the earlier racist development of the plenary power doctrine that enabled Asian exclusion, then anybody who wants something different has to achieve it in the political realm. So let me go to the next questions. Since different ethnic identities within Asian American pan identity have faced discrimination differently, do we see different voting behaviors between the different Asian American subgroups? And so there are people, there are political scientists who are studying this, who have studied this, and there are some generalizations in terms of certain groups being more conservative, but I don't have the expertise right now to speak on that, and so maybe it's safer for me to not comment on this. I'm happy to engage in conversation later with this person and in terms of directing to resources and things like that. So let's do the last question that I have in Q&A, and then I'll try to shift back into my presentation. So lots of states and federal government try to categorize Asian into more detailed subgroups. What is your opinion on that? Is that an effort to target certain sub-Asian communities? So there are times when different Asian subgroups are aggregated, and there are times when they're disaggregated. And I don't think that there's one simple answer in terms of, is it, are they negatively, are they motivated by trying to harm or not? I think it's very important to always think about, well, what is the reason to collect the different information? And so, going from the first question that we had, it becomes very important to understand the differences between different subgroups in terms of understanding, do certain groups face different challenges with regard to healthcare access, with regard to employment opportunities, with regard to educational opportunities. And then I know also with regard to health, it can become extremely important to collect the information differently in terms of it's funny, right? So thinking about, we use this broad category, this pan category, Asian American or Asian Pacific American, and you look at the tremendous diversity that exists within. It's like, what is it? There's not a common language, there's not a common food, there's not a common religion. What makes it a group? Now, one of the most powerful devices that constructs a group is discrimination. And so it's ascriptive identification that is forced upon certain groups. And that's partly why I think that critical race theory examines this earlier history to then try to understand. So the 1882 Chinese Exclusion Act, well, that was directed against the Chinese by name. Is that anti-Asian American? Well, but then what you see over time is, okay, so the Japanese are kept out by the 1907-1908 Gentleman's Agreement between Teddy Roosevelt and the Japanese government. And so Japan says, we're not going to issue any visas for laborers after that. The 1917 Asian Geographic Barred Zone Act keeps out South Asians. You have this consolidation in some ways of who is kept out. And then you have the citizenship cases. And these are, wow, it's on my slide here now. So Ozawa versus the United States in 1922, and the United States versus Thind in 1923. And so what you have is the original Constitution doesn't say anything about who can become naturalized. It just says that Congress shall produce a uniform law of naturalization. And so then Congress in 1790 says, okay, to become naturalized, you have to be a free white person. And then you have the Civil War happen. And then you have the naturalization statute changed to say you have to be a white person, or you have to be of African nativity or descent. And so then you get Takao Ozawa, trying to become a U.S. citizen, but he is immigrated from Japan, so he's not a natural born citizen, where the 14th Amendment would have made him a U.S. citizen. And so in a fascinating case, he actually came to the U.S. Supreme Court and said, I'm white. He pointed to his skin, he was fair-skinned, And he also pointed to some literature, like a cultural anthropologist who had visited Japan and talked about the white people who lived there. And so he presented this evidence to the court, and the court said, well, that's all good and nice, and decided, well, white we're going to take to mean Caucasian. You're clearly not Caucasian, regardless of how fair your skin might be or how white the people of Japan might be, according to this cultural anthropologist, and then said, all right, so you can't become naturalized. And then United States versus Thin, the South Asian man, says, all right, well, if you said a year ago that you have to be Caucasian, the ethnographic theory at that time had the Indians being of Aryan ancestry. And so he says, I'm Caucasian. I need to, you just said it's okay for me to become naturalized. And the US Supreme Court then in that case said, yeah, well, we mean white in the common sense notion, and you're clearly not white. But what you see is a consolidation of the racialization of Asian Americans as a group. So this is ascriptive. This is the lumping part. And then it becomes consolidated in the 1924 Immigration Act, where you don't need to mention Asians by name any longer because it says aliens ineligible for citizenship. And the only racialized group that is ineligible for citizenship are people from Asia. And so that's where the lumping part comes in. And it's the intentional construction of this Asian American broader racial group for the purposes of allocating resources, allocating rights in this country. But then, it's so that's the lumping part. But what about when the lumping ends up being harmful? In some ways, getting back to that first question, and that's precisely what the model minority notion puts forward. Let me just add, in terms of the genesis of the notion of Asian Americans being model minorities, it goes back to the 1960s. There was a demographer. His name was William Peterson. And he talked about the hardworking Japanese Americans who suffered tremendous discrimination and pulled themselves up by their bootstraps. And his point, though, was not just to compliment Japanese Americans on their industry and their hard work, but to say this was intended as part of a political argument against welfare for other groups. This idea that you don't need welfare, you just need people to work hard, you need people to be more like the models, the Japanese Americans. And then you get similar articles start to make their way, talking about the Chinese Americans in a similar kind of way. But again, this idea of the model minority flattens, aggregates, lumps Asian Americans into this category that is intended to divide, but also to erase the tremendous discrimination, inequalities that exist within Asian American communities. And so I see that I'm getting more questions now. So let me just pause for a moment and see if it makes sense for me to break into these. So let me talk about the last question that's here. There's another question about anti-miscegenation laws, and I may, in terms of the way the time is going, I may not quite get to that. But the question is, how has legislation and court cases such as Ozawa and Thin upheld the black-white paradigm in which many Asian populations attempt to align themselves with whiteness? And how does this influence attitudes of where to build solidarity with communities today? And in particular, in parenthesis, Harvard affirmative action case with influence from Edward Bloom and Andrew Yang's recent op-ed. So so that question pushes me ahead a little bit in terms of race theory. And so this idea of differential racialization. And so when we're thinking about race in the United States, sometimes the way people think about them are in terms of racial dyads. And so then one way to think about a racial dyad is, well, you have white and you have non-white. And another way to think about a racial dyad is, well, you have black and you have non-black. And so when we think in this dyadic kind of way, in terms of thinking about this question, what that creates in some ways are certain perverse incentives in terms of what is your litigation strategy going to be if you're trying to get rights for whether it's Takao Ozawa or Bhagat Singh Thind, or say that you're the father of Martha Lam and you're in Mississippi in the 1920s and your daughter is denied entry into the white school. And so there was this case out of Mississippi, and if you wonder, how did the Chinese get to Mississippi? There's this fascinating book by James Loven called The Mississippi Chinese. But following the Civil War, there was a time when Southern plantation owners, Southern landowners thought, well, the newly freed blacks aren't the kind of workers that we want. And so there were labor contractors who then went to the Southern plantations and said, the Chinese are the workers that you want working on your farms. And so then there was recruitment of the Chinese, and there's this community that developed in the Mississippi Delta, this multi-generational community. So one of the things that happened was that you had Martha Lam, who I'm trying to remember whether she was 9 or 11 years old. She's denied entry to the white school. And so then the father challenges that. Now, the attorneys had different choices in terms of how they could challenge the placement of Martha. So the exclusion of her from the white school, which meant that she had to attend the black school. And it would have been great if the attorney had pursued a theory that challenged segregation in education altogether. But instead, they pursued a more limited way to try to get rights for Martha. And the argument that they put forward was, well, she's not black. And because she's not black, she should be allowed to go to the white school. And so that litigation was in the form of an as-applied challenge that would not end segregation in public education in Mississippi, but instead would just say, well, as applied to Martha Lam, it's improperly applied because she's not black. And so you get perverse incentives sometimes in terms of, well, how do I pursue this theory? How do I, gain rights? How do I avoid discrimination? So it's possible that this might be something that Professor Iglesias next week gets into more. But this comes up in a very important way with regard to the racialization of Mexican Americans, the racialization of Latinas and Latinos. Because of this weird Texas District Court case, I want to say it's In re Rodriguez, and I think it's in 1878, but there is this immigrant from Mexico, and the question is, can he become naturalized? Now, remember a moment ago, I talked about the naturalization statute. It permitted white and also people of African nativity or African descent. And the court there decided, well, because the Treaty of Guadalupe Hidalgo in 1848 permitted people of Mexican ancestry to become citizens, he decided that ultimately that Mexicans were legally white for purposes of the naturalization statute. And so then once they have legal whiteness, it actually then advanced a certain mode of civil rights litigation for Mexican Americans, which was, well, I call it the other white strategy, which is, we're white. And so your segregation statutes can't be enforced against us. It ends up operating in a way to come back and bite them. There's a case, a desegregation case out of Corpus Christi in Texas. And there was a lawsuit that said that Corpus Christi needed to desegregate. And the school district in Corpus Christi, what they did is they put together the Black and the Mexican Americans, the Latinos and Latino students, and said, we've segregated, or I'm sorry, we've desegregated, because now you have Blacks and whites together. You know, ultimately that didn't hold up, but you see the challenges that exist in terms of trying to think about, if you're trying to achieve justice, if you're trying to in some ways remove racial subordination in the United States, what are you going to do to do it? You might have what I would describe as myopically short-sighted ways of approaching it, and I would describe Gong Lam as an example of that. And I might even describe the earlier strategy that LULAC, the League of United Latin American Citizens, pursued, was also in some ways short-sighted, because in some ways it didn't understand that it's not really about white, non-white, or Black, non-Black, but in some ways it's really maybe about maintaining a certain notion of supremacy for a certain group. And so, you know, when we're thinking about race and race hierarchies, sometimes that's what people try to do. So race theorists, like, okay, so you have a group on top, you have a group on bottom, and then everybody else, you know, you just sort of sort out, you know, where you're going to be, and sometimes it ends up creating this notion of, you know, a race to the bottom, where you're like, I'm more oppressed than you, as a way then to try to, I'll describe this as to get crumbs, right? It's to get the crumbs that are sometimes made available to you. Now, I think that ideas of race hierarchies can be powerful, but I think they're also limited. And so that's why more recently I've been thinking about and trying to understand things more in terms of this idea of racial triangulation. Now, many of you may be familiar with the case Plessy versus Ferguson. It's an 1896 case, and you may know it as the case that established separate but equal. You had Homer Plessy, who was phenotypically 1/8, you know, he was 1/8 African-American by ancestry, somebody who could pass for white, and that was actually part of the litigation strategy. The argument that appears in the briefs 100 years before, well, maybe not 100 years, but many decades before the idea of social construction of race makes its way into the academic literature. I mean, they were making that argument there. People may be familiar with Justice John Marshall Harlan and his famous dissent, where he talks about our Constitution is colorblind. And sometimes people look at that and say, gosh, he was a civil rights hero before his time. But the one thing that has always bothered me about many con law casebooks is that they often don't include the paragraph that I have on the right. And it's his paragraph in that same dissent, where he talks about the white race deeming itself to be the dominant race. And he says, so I doubt not it will continue to be for all time, if it remains true to its great heritage. It's hard to find a more naked pronouncement of white supremacy in the US Supreme Court opinions. And so he wasn't really about civil rights. But then the other part that is usually not discussed or included in casebooks or discussed in con law classes is that part of the problem that Justice Harlan had with the Louisiana statute was, and the specific example that he provided was that a Negro veteran, and so an African-American who fought for the Union could not sit in the same car as a white person, whereas a Chinese person could sit in the same car with a white person. And so what we see here is this triangulation. In some ways, we have the other, in his example, being the Chinese person, and then you have the equivalence of the white person and the Black Union veteran. And so this idea of racial triangulation, there's this sociologist, Claire Jean Kim, who did this fantastic article, has been putting forward this idea that when we're thinking about the way that different racial groups operate, rather than thinking about dyads or rather than thinking about linear hierarchies, that maybe there is triangulation going forward. And so, you know, one of the ways to think about this is you have different axes, so inferior, superior. And for her, she says, you know, you have foreigner versus insider. And in some ways, you have Asian Americans who may be thought to be superior to Blacks, but they're foreign, whereas the Blacks are definitely considered to be insiders. And so when I think about this in terms of modeling for, you know, different, you know, so here's building off of what she did. So Asian Americans as a model minority. What you have when that is put forward, you have Asian Americans in some ways being placed on a horizontal plane with whites, but it's intended then to distinguish from the similar treatment, Black and Latinx. And then another way to think about it is, well, what if Americanness is the horizontal axis? Well, you have whites and Blacks along that horizontal axis, and you have Asian American and Latinx outsiders in that way. And what you have happening is not just one of these operating or the other operating, they are used and deployed depending on what it is that the person is trying to accomplish. And so, you know, Dana Rohrabacher, who was a former congressperson from California, he sort of seized upon Asian Americans as, oh, the model minority, and that's why, you know, they're the ones who are being hurt by affirmative action. And, you know, there's a friend of mine who, a professor at DePaul, Sumi Cho, who talks about it as racial mascotting. And so Asian Americans were Congressperson Dana Rohrabacher's racial mascots for purposes of challenging this policy that he didn't like. But at the same time, Dana Rohrabacher was anti-immigrant. And so, you know, depending on the issue, he deploys whatever mode works. But I think it becomes important to think about this in terms of thinking about the way that different racial groups operate and exist, the political structures and the devices and the strategies that are used if you're going to try to break through this. If you're going to try to understand, well, how do we build a position of solidarity when there are so many differences between us? And so let me pause there. I see 1:30 here, so that means 4:30 there. And I think, do we just have formally 15 more minutes?
Yeah, I believe we have about 20 minutes.
Okay. And, you know, I think we had spoken earlier about, you know, I'm happy to stick around for anybody who wants to ask additional questions, but
yeah, so we'll allow for, so the ask is of folks, we've been getting a lot of questions, but the ask of folks is to provide us with more questions because we're going to do an after presentation and we'll be able to record it and share it with you all to answer every question that's posed to us. So please send us in via Q&A or chat.
Okay, so I see a question about the US Census and what role it plays in constructing racial realities, and what implications do you think the 2020 census, especially in the midst of COVID, will have for APIDA, Asian Pacific Islander? I know that's a particular phrasing at Johns Hopkins.
Desi.
But we'll have for Desi, right? So okay, folks in the U.S. today. So I love the U.S. Census, you know, in part because of the information that is there. You know, I don't know how much time you've spent with the census data and just the vast amount of information that has been collected. So first, does the U.S. play a role in constructing racial realities? And my opinion, my answer to that is absolutely. You know, it's fascinating going back because I've been looking at the census and thinking about the different ways that Asian Americans have been counted and also other racial groups. So there was a time in the U.S. Census where they actually included mixed race categories before, you know, much before they started maybe 20 years ago, collecting mixed race as an additional category. They included whether somebody was mulatto. And so there was a black category and there was a mulatto category. And then 1920 was the last year that, if my memory serves, 1920 was the last year that they included a mulatto category. And my hypothesis about this is that this was in conjunction with the 1924 Immigration Act, the change to drop it. Because in some ways, to recognize a mulatto category was to recognize race mixing. And so instead of recognizing that you had mixed race categories, they actually worked to flatten it out. And so after that, it was just a Black or Negro category. And then when we think about 1980 as the first year that they had the US designated term for ethnicity, the Hispanic category. Before that, you had, I'm trying to think whether it was 1950, you had Spanish surname, you had Spanish surname and speaks, Spanish mother tongue. These are attempts in some ways to categorize people. And so it's interesting then to think about, why do we categorize people? What is the need for it? It's such a complex question because in some ways, we might hope to be in a post-race world, but when you have race discrimination occurring, well, you can't really go with what Ward Connolly wants to do with the so-called Racial Privacy Act, this idea or notion that my race is private and the government has no reason to collect it, because race is crucially important with regard to the enforcement of the Voting Rights Act. You need to collect this information, and it came up in the census litigation last year. COVID, so the attempt to use or to include the citizenship question in the 2020 census was intended to drive down responses from certain immigrant groups, especially with Latinx, but also with regard to Asian Americans. When you have the combination of, even though the US Supreme Court said, you can't have that question, the damage a lot of the damage has already been done. There's suspicion. And then to the extent that COVID-19 is going to limit the efforts of the census enumerators to go do the knocking on doors has in previous administrations of the census been crucial to collect the information. You're going to have less of that happening. And so then you're also going to have this thing where to the extent that technology creates barriers to going online and filling out the census information, you're going to have a real serious problem with undercounts. And Latinx voting power is going to be affected. APITA voting power is going to be affected. But not just voting power. The census numbers play a key role in terms of the allocation of federal dollars. And so the undercounts are going to be tremendously harmful. Do I have an answer to, like, do I have a fix for it? I don't have a fix for it. But the census has a tremendous role to play in terms of confronting race identities. And I think we face a very fearful time right now in terms of getting the information that we need that's going to ensure that communities that we care about are not hurt in terms of political power and representation, but also with regard to dollars. So in the interest of time, I'm gonna just sort of try to wrap things up. I mean, I realize, there's some slides, some information that I didn't get to in this wonderful free-ranging discussion. The questions have been great in pushing this conversation. But I want to return to the moment, which is you have President Trump and the Chinese flu, and I've spoken a little bit about the dangers that presents. But then, on the right, it's a screenshot of one of Joe Biden's recent political ads. And some of the language includes, but Trump rolled over for the Chinese and the travel ban he brags about. Trump let in 40,000 travelers from China, not exactly airtight. This ad upset me because it seeks to, it's dog whistle politics again. And candidate Biden makes similar mistakes. China and Chinese, they're not the same. And he should know better in terms of understanding that the Chinese are not differentiated from Chinese Americans and other Asian Americans. And then the last part of it, not exactly airtight. So candidate Biden, what's your criticism? Would you make it airtight? Is that where you're going with this? Because if the criticism is that what you did wasn't airtight, well, what's the fix? And so, the important thing is we need to I think it's important that everybody be held accountable to their words and their actions and the way that they operate. And my hope is that candidate Biden learns from this. I know that he's gotten some pushback about this, because what you get is China to the Chinese Americans and other Asian Americans. You get, again, dog whistle politics. There was that earlier question about Andrew Yang. We Asian Americans are not part of the virus. We can be part of the cure. And his pitch is, let's be more American than others. Let's wear, he even says, wear red, white, and blue. And he invokes the example of Japanese Americans during World War II, the large numbers that volunteered for service in the US military, and that's what's necessary during this time. And I just have to say that I'm more persuaded by a counterpoint that was published in the Washington Post. And actually, when this thing from Andrew Yang came out on April 1st, I thought, oh, April Fool's Day, it's a joke. But sadly, he wasn't joking. Showing our Americanness is not how Asian Americans stop racism. And so then when we think about what is required for a course correction, and this is my final slide, and I'm only gonna get to, sort of the overview in some ways. So what is required for a course correction? Well, one is education. It startles me sometimes how little people know about the history of the anti-Asian immigration laws and how that operated over time and the impact on communities. I didn't get to show that an earlier slide. There were times when the annual quota from all of Asia in 1963 was 2,000 some odd people. All of Africa was 1,000 some odd people. All of Europe was around 100, 1,300, 30,000. I have to go back and look at the slide for that. America looks the way that it does because of all of that. It was intentional. And so then when we think about, what does America look like? Well, it looks like what it does, the numbers, through the very specific actions, the very conscious construction of who it is that can be American. And that ends up helping to build the notion of who is foreign and who is not. And so education becomes key in terms of that. And also, in particular, that's why we spent so many years fighting in Arizona for ethnic studies, for Mexican-American studies. You need that to be made possible. You need more civics education. You need more history. You need more social studies. Politics. I do believe that people who are more informed in terms of history, that it will affect the way that they decide to participate in the political sphere. And then with regard to law, it's like when the travel ban came about, and I saw the attorneys and the crowds going to the airports, I was so heartened by that. But then there was also this moment for me where I got excited because, maybe this is the opportunity to fix two things that exist, deformities within US constitutional law. And for me, I saw it as an opportunity to revisit the plenary power doctrine that gave so much power to the executive and Congress without sufficient judicial oversight. And then also an opportunity maybe to overturn Korematsu. The headlines following Trump versus Hawaii included things like Korematsu overturned. Not really. Hawaii versus Trump or Trump versus Hawaii is a very dangerous case, because before Trump versus Hawaii, you couldn't really cite to the Korematsu case because it was kryptonite. It's like, how could you rely on what history and most people think is a racist case, and also wrong? But Trump versus Hawaii actually reinstates all of the reasoning in Korematsu. And that's why it becomes super dangerous, because you couldn't cite to Korematsu before, but now you can cite to Trump versus Hawaii. And so with regard to his 60-day pause on green cards, and who knows how much longer that's going to go, their briefs, the US Department of Justice government briefs, that I'm certain is going to happen, it's all just going to be, see, Trump versus Hawaii. And it's like, that's, sorry for the wordplay, but that's their Trump card. And that's stuff that we need to fight against. And so we're nearing the end of time. I want to make sure if there are questions, and again, I'm very happy to stick around to answer more questions, but that's what I have in terms of my sort of the way that I wanted to go through this material. And so thank you all for your attention during this time. And I know it's not over yet, but I want to make sure to leave some time for Q&A before the after Q&A. So am I right, Joseph, about the format?
Yeah, so we're opening up. We want to make sure we leave at least 15 minutes for engagement. So if you have any questions, please post them through our Q&A or even in the chat. And any questions, again, that we don't get to, we will make sure that we record after the presentation offline and make sure that we post them. But this is a great time and opportunity. And if you'd like to ask a question live, that's another piece of this awesome presentation that we can incorporate into. So just let us know that you want to do it live and we can accommodate. I think we have a question in the Q&A. Oh, no. We are actually going to give, I think one of the slides that we have is going to be able to connect with Professor Chang. So we'll make sure that we get that information to you as well.
I think somebody asked about my email, so I'll just go ahead and type it.
And Kwame, do you have any folks on your end?
I don't see any additional questions on my Q&A. And I'm also reviewing the chat. I see Professor Galesius wrote a comment also with a question as well. Maybe we can ask that as well. Commenting on your such a great presentation, no desire to interrupt, but you hit on a very, very important challenge confronting all progressive activism. Race is always used to divide and conquer both within groups and across groups, e.g. Using different races to break collective action. What strategies work best to combat that use of race?
So that's a wonderful question, and it's a tremendous challenge. And so for me, it's always been about how do I make a connection to somebody else? How am I able to see myself in them? And then also, how might I help them to see themselves in me? So, you know, as an Asian American who cares about civil rights, one of the things is I can't do this work without knowing African American history. One of the challenges that I've posed to those doing civil rights who are members of other groups is, how much have you learned about Asian American history? How much have you learned about history, you know, Mexican American history? Because if we really are going to get to the place of solidarity, we need to be able to see ourselves in others. You know, my mentor, the late Jerome Culp, at the first LACRIT conference that was held in La Jolla, San Diego, said, you know, posed this question to the group, which is, how do we come to participate in the struggles of those who are not us? And it's a question that I return to all the time because, you know, I try to keep it as a guidepost. How do I come to participate in the struggles of those who are not us? And in some ways, it's by expand the notion of who is the us. And in some ways, it's through the exploration of history. And so, you know, earlier there was the question about, you know, there are so many different Asian subgroups, and the histories of the different Asian subgroups are so different. I would love to spend another, you know, hour just going into like the different trajectories of, you know, how did you get to the 1907, 1908 Gentleman's Agreement with Japan? And then to things like, you know, the Tidings-McDuffie Act of 1934 and what it did to Filipinas and Filipinos, and on and on and on, because each of the histories is different, each is unique. And I hope that nobody comes away from this presentation thinking that there is one monolithic Asian American history. It's so rich, it's so diverse. You know, I also still have so much to learn. You know, in some ways, I know that one of the areas that I know that my own work is lacking is with regard to the Pacific part of things, Pacific Islanders. You know, I know that I don't know enough about that, and I do try to push myself. But again, I acknowledge that as something that I don't have enough of in my work. And I need to do that because that's how we are able to work together. But it's easier to have conversations with like-minded people, and I guess one of the things that quite possibly I don't do enough of is to talk with not like-minded people, because have I done enough really to understand how they've come to their views. So.
Thank you, Professor Chang.
So wanted to see if we could possibly even ask, I'm being a little selfish here in the time that we have, but I wanted to talk about how to, in your experience, particularly in your field as a crit professional and theorist, but also someone who is working in a higher education system and also has a background in law. How have you successfully navigated, creating change, particularly around reconstruction of history and curriculum development? Like, you talked about working with folks who are specifically not like-minded, but what has been successful in creating change at your institutions or even in systems that will allow and also inform administration to create, socially just schools?
Yeah, so one of the things that I've benefited from has been able to, although not at my school now because of the courses I teach, but at a previous school I taught at, I got to teach Asian Americans in the law. I got to teach racism in US law. And then because I was teaching those courses, I actually had Latinx students come to me and ask if I would teach Latinas and Latinos in the law. And because they had approached the Latinx professors on the faculty first to see if any of them would teach it, and they said no. So I agreed to do it as a placeholder, but I told the students, you need to show up, and in order for the faculty to believe that this should be a course that continues in the curriculum, you need to sign up for this course. And for me, it was, when I say was willing to do it as a placeholder, it was so that in future years, if we're hiring somebody, law schools usually aren't going to hire somebody saying, oh, I want somebody to teach Latinas and Latinos in the law. But, they'll look for a contracts professor. But if that person teaches Latinas and Latinos in the law, well, that can be a plus. But you need to create, to be there so that the faculty of the school believes that it's needed. And so it's this two-way street between professors and students, where the students can help the administration understand that we have certain needs. You don't have X, Y, and Z. You don't have ethnic studies. You don't have Asian American studies. Your American Studies department doesn't look into do enough ethnic studies. So much of what has changed has come about because of student activism. And Professor Montoya in the session last week talked a little bit about that in terms of the history of critical race theory, talking about what happened at Harvard, what happened with Berkeley, the student activism that led to the changes. And the good thing is that there are professors who are willing, very happy then to work with the students, but it's in partnership that I think that I've been able to be successful. And then for me, what I wanted to do in this last sort of, several years in my career is to take the ideas from critical race theory and put them into action. And so then, I can write articles about implicit bias and how it operates, but what if I can get the courts to acknowledge implicit bias and to then make changes to the administration of justice? We had a fascinating case in Louisiana where the lawyer for somebody who was challenging his death sentence, asked us to do an amicus brief. That's a friend of the court brief, so we're not representing him. But they asked us to talk about how it doesn't matter that there were 3 African-American women on this jury sitting in judgment of this African-American man, but instead that the jury pool, the pool from which jurors are selected, included no African-American men. And so then we got to put forward the theory from critical race theory about intersectionality, that it's not just race. You can't just say, oh, they're African-American women, and so there's no race issue. That it's actually more complicated than that. And so this opportunity then to try to educate the court, we went into it not that optimistic, because we didn't expect the Louisiana Supreme Court to recognize intersectionality. But the other part of it is that it's the long game. If you can't do things thinking and hoping, oh, I'll just do this one thing and it'll fix itself. It's the long game. It's a marathon. And the great thing about doing this work is that you're not alone in doing this work. It's a community, and it's a community that sustains each other. And so you asked how I was able to navigate. It's the community that was able to help sustain me. But the ideas, the theory, the tools that I learned, that I now have the privilege to put into, briefs that I file in court. What a privilege.
Awesome. So we have 3 minutes left. If there are any more burning questions, I think we are at the tail end of our presentation. I'm going to have Kwame kind of speak to what's next, our last event.
A round of virtual applause to Professor Chang on an amazing presentation and engaging our Hopkins community around the framework of the Asian critical race theory. We are so happy that you joined us and provided some really valuable tools that we can use within our position within Hopkins and beyond. We are now, we will be sending out an evaluation assessment at some point this evening so we can get your ideas and thoughts about today's session. Also, if you participated in last week's session, we will send out the assessment as well so that we can get your thoughts and ideas on how we can better improve, as well as get some thoughts on how well the session went today. So our last session is scheduled for April 30th, same time, same place. April 30th, we're going to have Professor Elizabeth Iglesias from the University of Miami School of Law. We're so excited to have her. We're going to dive deep into the Latinx critical race theory. We're going to meet back here 3:30 to 5 p.m. via Zoom, and as well as Facebook Live. If you did not get a chance to see last week's presentation, you can also go to YouTube and see the amazing work that Mr. Cologne did. He's the producer of the of putting all of that together so that anyone that were not able to participate, they can hear the valuable information from Professor Montoya as well as Professor Chang. If you all don't have any further questions, we look forward to having you all next week.
Awesome. Any last remarks, Professor Chang?
Oh, so, thank you so much for the opportunity to engage. And I'm very happy to talk with folks offline, email. So thank you for the opportunity.
Oh, thank you. Thank you so much. And your colleague says big ups to Professor Chang. So she said, great to see you. So we are so delighted that we can be bonded in community, and we look forward to next Thursday to hear about the LACCRIT critical race theory and Professor Iglesias. So we'll see you next time.
It's like, how did things change? And things changed group by group. So 1943, the Chinese, our Exclusion Act is formally excluded, and now they can become naturalized. Koreans, they tried to introduce legislation for Koreans, but that failed because Korea was a colony of Japan. It's like, we don't get any benefit from it because the China at the time was an ally of the United States. So, there's a story of interest convergence there. And you get the story of Pearl S. Buck, helping to lead the delegation to lobby Congress to allow the Chinese to become naturalized. And then a quota is set for them to come in of 105 people a year. 1946, Filipinos, the law gets changed. So now they can become US citizens, and their quota is set at, it was either 50 or 100. And then in that same year, with decolonization of India and Pakistan, you had those included. And then 1952 is when wholesale, the racial bar denaturalization was lifted. So even after World War II and that experience, the Japanese immigrants couldn't become naturalized until 1952. And then, the numbers that I talked a little bit about, so all of Asia gets 2,000 some odd people a year. All of Africa, 1,000, right? Nuts, right? And Europe gets 100 some odd thousand each year. Why does America look the way that it does? By design.
Mm-hmm.
And then 1965 is when things start to change in terms of the numbers.